You just heard a knock at your door, and a stranger handed you a stack of papers saying you lost a lawsuit over an old credit card. It's 11 at night, and you're staring at the walls of the only real asset you've ever owned. You can't sleep because you keep picturing a sheriff putting a giant padlock on your front door. You're terrified that one mistake is going to leave your family out on the street. Take a deep breath. You're watching Scribble Law, where we break down everyday legal concepts for ordinary, hardworking people. This channel is strictly education, not legal advice, because laws change drastically depending on where you live. We're going to walk through how these situations actually work, from the absolute most terrifying outcome down to the safest way to protect your home. We're ranking the realities of a judgment against your house, starting with the absolute worst-case scenario and walking down the ladder to the safest ground. Let's look at the worst-case scenario first. The absolute worst thing that can happen is an execution sale. An execution sale is when the court actually authorizes the local sheriff to seize your property, sell it at a public auction, and use the money to pay off your debt. When that piece of paper says you owe money, it's called a judgment. A judgment is simply a formal court order stating you owe a specific amount to a specific person. Can a creditor actually force an execution sale of your house? Yes, they can, but it's incredibly difficult, incredibly expensive for them, and quite rare in many jurisdictions. If this happens, it means the creditor has exhausted every single easier option and decided to go straight for the foundation under your feet. It's a brutal process that can take months or even years to finalize, and it usually only happens when there's a massive amount of money on the table. Why is an execution sale so difficult? Because most states don't want a minor credit card debt to put a family out on the street. Because of this, we immediately step down the ladder to a lien. A lien is a legal claim or a legal lock placed on your property title. A property title is the official document proving you own the house. When a lien attaches to your title, you can't easily sell the house without dealing with the debt. The creditor doesn't force a sale today. Instead, they essentially wait you out. If you ever try to sell or refinance the house 10 years down the road, the title company handling your closing will demand the lien be paid off from the sale profits. A lien turns your house into collateral, which is simply an asset a creditor holds onto until a debt is settled. Most creditors prefer a lien because it's cheap, requires very little effort, and guarantees they get paid eventually without fighting a messy auction battle. Now we step further down the ladder to the force that stops both the execution sale and the lien. That force is a homestead exemption. A homestead exemption is a specific legal protection that shields a certain amount of your home's value from creditors. Laws vary wildly by state, so you absolutely must check your local rules. Let's say your house is worth $300,000. If your state grants a homestead exemption of $100,000, it means the first $100,000 of your equity is completely protected. Equity is the amount of money you'd pocket after selling the house and paying off the mortgage. Because of that exemption, a creditor can't simply kick you out to auction off the property. If they forced an execution sale, the bank gets paid first, and then the protected homestead exemption gets paid second. If your equity is lower than the exemption amount, the creditor gets absolutely nothing from the sale. They would end up paying legal fees just to lose money. That math prevents the auction from ever happening. What happens if your equity is high and the house is worth millions? Then you step down to the next protection, which is the creditor's basic cost-benefit analysis. An execution sale isn't free for the person suing you. They have to pay hefty court fees. They have to hire specialized lawyers to navigate property laws. When a creditor chases a debt, they can usually only touch the specific ownership share of the person who owes the money. If you own a house with your spouse, and the judgment is only against you for an old business debt, the creditor can't easily auction off the whole house. They only have a legal claim on your half. But you can't saw a house in half, so auctioning a single owner's share is a logistical nightmare for creditors. No investor wants to buy half a house and move in with your angry spouse. This tangled web of ownership creates a massive headache for creditors, making them highly motivated to accept a settlement instead of fighting for a forced sale. The complexity of untangling joint property acts as a massive, practical shield against an execution sale. Now we reach the safety zone. We're at the level where the law flat out protects you, no matter what the creditors say. There are certain types of debts where private creditors can't touch your house at all. Remember, this varies heavily depending on your jurisdiction, but generally, there are strict boundaries on what a regular creditor can do. If you owe money because a credit card went bad, or because you couldn't finish paying off a truck loan, these are considered unsecured debts. An unsecured debt is money borrowed without any specific property attached to it as a guarantee. For a normal unsecured credit card judgment, they can't throw you out on the street. If they get a judgment, they can garnish your wages, meaning they take a percentage directly out of your paycheck before you even see it. They can grab the cash sitting in your checking account. But practically speaking, your primary residence is usually protected by that homestead exemption we just talked about. What happens when the debt isn't a credit card? What if you've a secured debt? A secured debt is a loan where the property itself is the guarantee. If you stop paying your actual mortgage, the bank can absolutely take your house. The bank gave you the money to buy the property, and they hold the primary lien. When you stop paying, they initiate a foreclosure. A foreclosure is the specific legal process a lender uses to take back a property after missed payments. But remember, a foreclosure is completely different from a general judgment execution. An unsecured credit card company has to stand in line behind the bank, and if there's no money left over, they get nothing. Finally, we're at the very bottom of the ladder, the absolute best-case scenario. This is where you understand the legal rules and take control of the timeline before things spiral out of control. When that lawsuit hits your mailbox, you need to know exactly when a lawyer becomes absolutely necessary. If you own a home and you're served with a lawsuit for a massive amount of money, ignoring it's the fastest way to invite a lien or an execution sale onto your property. A default judgment is what happens when you completely fail to respond to a lawsuit, and the judge simply awards the creditor everything they asked for. You must respond to the paperwork and show up to court. You don't have to hire a lawyer for every small claim, but when real property is involved, you need professional protection. A local attorney can file for exemptions on your behalf, ensuring the court formally recognizes that your home equity is protected by state law. They understand exactly how to negotiate a settlement, which is simply a mutually agreed upon compromise to end the dispute without going to trial. Sometimes filing for bankruptcy is the right move. Bankruptcy is a legal process that wipes out or reorganizes your debts entirely. When you file the paperwork, an automatic stay goes into effect. An automatic stay is a powerful legal freeze that immediately stops all creditor collections, lawsuits, and foreclosure actions dead in their tracks. Knowing these exact tools exist gives you the power to protect your family from losing everything. Navigating a lawsuit is incredibly stressful, but understanding the actual rules takes away the fear of the unknown. Creditors rely on fear, but the law provides very specific shields to protect your home and your family. Have you ever found a surprise lien on a property title or received a court summons that made your stomach drop? Tell me your story in the comments below. If this breakdown helped you understand the real threat of a lawsuit against your home, pass the video along to a buddy who is currently sweating over an old debt right now. Make sure you subscribe to Scribble Law so you always know the exact rules of the game before the legal system tries to knock on your front door.